Why don't we get started? Okay, and we're recording? Great, okay, thanks so much. Good afternoon, everyone. For those of you who don't know, and I want to welcome all of you, all of our member presidents and senior advisors to this webinar. This is the third of 3 sessions that ACCU has hosted to address member campus concerns related to the outbreak of COVID-19 and the implications for the fall semester and beyond. All 3 of our webinars have been made possible through partnerships between ACCU and trusted organizations. Today, we are most grateful to the law firm of Hogan Lovells, which has been a longtime advisor to ACCU. We are especially grateful for the wise counsel of Elizabeth Mears and Joel Buckman of Hogan Lovells. We also want to acknowledge the leadership of ACCU President Father Dennis Holtschneider in bringing today's webinar to fruition. 2 housekeeping notes. I'm sure you'll be very familiar with them at this point in our Zoom evolution. First of all, please keep yourself on mute so that we can minimize background noise. Second, please use the chat function to raise a question. We will be monitoring these questions and will address them during the Q&A segment as possible, or we will follow up with participants after the webinar. Today we're going to be talking about risk management and campus liability related to COVID-19. Let me introduce our moderator right now, who will then present our speakers and get us started. Joel Buckman is counsel in Hogan Lovells Higher Education Practice in Washington, D.C. He helps colleges and universities comply with federal law and handle some of their most significant challenges. He's worked with multiple ACCU member institutions on a range of issues, including on matters related to religious mission and identity, civil rights, faculty employment and labor, accreditation, and federal student financial aid compliance. Joel, let me turn it over to you and leave it in your capable hands.
Great, thank you, Paula. And if we could share the presentation.
Absolutely.
That would be fantastic. So we will be working through a slide presentation here with you all this afternoon, and we're delighted to be with you. We know that reopening in the COVID-19 era is a challenging topic, and we're really happy to try to come alongside you and shoulder some of that burden. I have with me today 2 excellent colleagues, Michael Kidney and George Ingham. Both are partners. Michael's practice focuses on defending class actions that seek damages for alleged economic and personal injuries. He's got significant experience representing universities, including Yale in a class action brought by current students, as well as a class action seeking refunds from the University of Pennsylvania as a result of a dispute stemming from the transition to online learning in response to COVID-19. George Ingham has represented and counseled universities in a wide range of employment matters, including policy development, internal investigations, disputes with faculty, and of late, of course, COVID-19 response. I can have the slide. So the big picture in terms of what we want to cover today are really 3 questions. What are the key vectors of COVID-19 liability risk? What's the nature and extent of the potential liability, and what can an institution do to mitigate it? And really what we're thinking about here is we know there are advantages to bringing everyone back to campus. There's the advantage of just getting back to normal. There's the advantage of the living learning environment. And of course, there's a revenue associated with the living learning environment. And that's one side of the ledger. On the other side of the ledger is, of course, keeping people safe, which we know from our university work is top of mind for institutions. And for ACCU institutions, and also managing legal risks associated with COVID-19 and keeping everyone safe. So those are the big quick picture questions we'd like to focus on this afternoon. So the potential liability varies significantly depending on the nature of the relationship between the university and the parties. You know, in preparing for this presentation, we saw an article on Catholic higher ed reopening, and the headline basically was "Extreme caution is the order of the day when reopening for COVID-19." And they had a picture of statues on DePaul's campus, and the statues had surgical masks on the statues themselves. And while, you know, you probably don't have liability from statues per se, you do potentially have vectors of liability from the range of other communities that interact with your campus, whether it be students, employees, independent contractors, family members or friends, the whole gamut. And it's not the focus of today's presentation, but there also could be liability associated with compliance with federal, state, and local government rules and regulations, both in general and around some of the relief acts and legislation that have been passed. So, for example, under the CARES Act, there's the obligation to continue to employ your employees to the extent practicable. And if you don't comply with that, there's the potential for treble damages. So just to flag that. The next slide, please. So our primary focus today is going to be on students and employees. It's also important to know, you know, we're not epidemiologists, and we know that many of you are thinking through all the practical ways to keep your campuses safe. I would say our focus this afternoon is really going to be on the legal frameworks and trying to identify tools you can use to address that legal risk. And here's our roadmap. We're going to talk through the risks, the vector of risks associated with students, employees, and then personal injury. Personal injury is a cross-cutting topic applicable to both students and employees. And then we're going to try to bring it all together with 10 steps to consider to mitigate legal risk, and then we'll take your questions. With that, I'll turn it over to Michael. Michael, I think you're on mute.
Can you hear me now?
Yes.
Yep, we had you, Michael.
Okay, great. If you can go to the next slide. Thanks very much for that introduction, Joel. What I'd like to start with here is when we're talking about students, it's important to keep in mind that there are various types of claims that students can bring. They can bring refund claims, they can bring privacy claims, they can bring individual disability claims, and they can bring tort claims. Tort claims are generally the avenue that a student would assert if they are alleging that they sustained some sort of personal injury, for example, from COVID. So let's talk about refund claims first. So these are the claims that you have seen in the news. Perhaps some of you, unfortunately, have been a recipient of these claims. There are well over 100 institutions, educational institutions, that have now been sued. These are all class actions, and they are all seeking some sort of refund of either tuition, fees, room, or board. Interestingly, the class actions do not contest that universities generally should have shut down in the spring due to the threat of COVID. What they are seeking is, generally speaking, a partial, not a whole, but a partial refund of tuition, room, or board. And to do that, they're alleging a couple of different causes of action depending on the particular class action. Almost all of them are alleging contract claims, and what they are alleging is either that there was an explicit or an implied agreement to deliver a certain educational product and that the students allegedly did not receive that as a result of having to leave campus. Interestingly, a lot of these, my view is that a lot of these contract claims are really just dressed up educational malpractice claims, but courts generally have rejected educational malpractice claims. So the complaints generally are refashioned as contract claims. Not every class action, but many of them also have consumer protection law claims and quasi-contract claims. The quasi-contract claim is generally an unjust enrichment claim, saying the student paid the full tuition, room and board and fees and didn't receive everything they were expecting. And the consumer protection law claims are essentially claims that the student was told that they would have one kind of experience and ended up having another. So it's important to keep in mind that the contract claims can also involve third parties. So it's important to review your agreements with third parties that might deliver a portion of the student's education, for example, junior year abroad, internships, clinical education. And in reviewing those agreements, seek to confirm that the ability of the third party to continue to provide the education is in place. So, for example, health and safety considerations. Is the third party able to deliver the product that is expected consistent with those considerations? And also think about an allocation of risk between the parties if a personal injury is sustained. For example, if a student becomes ill during a junior year abroad, would the third-party provider indemnify the university for any claim against the university, and/or do they have insurance to cover that? It's really something that has to be evaluated on a case-by-case basis, balancing the risk and reward in each instance. So let's talk a bit about the potential defenses to refund claims. A number of universities have already filed motions to dismiss. They're generally not fully briefed, but probably within the next maybe 60 at the very earliest, maybe 90 days, we're going to start seeing various judges rule on some of these early motions to dismiss. And the good news is there are very strong arguments that are raised in these motions to dismiss. First, impossibility of performance. Essentially, that means the university was just unable to provide all of the services that it contemplated providing. For example, students have asked for a refund of the portion of the fee attributable to gym membership, and that providing a gym to students who are off campus is simply not possible. Another argument that universities have raised is that there is no breach of promise because the universities never represented what they would do in the event of a pandemic. Another consideration to keep in mind is many universities, including perhaps your own, don't have an explicit enrollment agreement with students. As I mentioned earlier, courts have generally rejected educational malpractice claims. And one argument that we plan to make, for example, is that these are basically dressed up educational malpractice claims because students received educational services, albeit remotely. For them to now say those remote educational services were in some way deficient is essentially a way of saying that they didn't receive the same level of education they expected, which is another way of saying there was an educational malpractice claim. For many students, there was an absence of damages because for many students, they were able to receive an educational services just fine, and there was no significant deterioration in what they received. For example, a student in a history class is going to, if that history class is presented through Zoom, presumably would have a very good experience. And whereas maybe a student who was in a clinical lab course might have a better argument, we would expect, for a problem But there we come to the issue of class certification, and for a court to certify a class, there has to be a predominance of common issues, and we think that each individual student's various experience there's a strong argument that as a result of that, there's going to be a predominance of non-common issues rather than common issues. Next, unjust enrichment is not applicable in many states where an agreement is alleged. In addition to that, for many universities, their costs went up, not down. So from that standpoint, there was no unjust enrichment. And then last, no consumer protection claim where the elements of the statute were not met. And those elements are many and include causation and damages. So what are going forward, now that we've seen these class actions, now that we know that the plaintiff's bar is ready to file more of them, what can we do to cut down on the risk going forward? One is, if your institution utilizes an explicit student enrollment agreement, to revise that with the lessons learned from last spring. And if your institution doesn't do that, to in other communications to students, make sure they understand that you reserve the right to shift the schedule and the possibility of going online, add a force majeure clause to any agreement, and state with specificity what educational services the institution is undertaking to deliver, both if people are on campus and if they are not. It is a good idea to put students on notice of these conditions as soon as feasible and before students arrive on campus. If students learn about this after they get to campus, they can say, well, had I learned about it earlier, I wouldn't have enrolled in this semester. So it's a good idea to give them this information before they make a decision on whether to enroll in this coming semester. Consider too your institution's refund policy vis-a-vis the leave of absence policy. For example, a lot of institutions have a cutoff date by which if a student withdraws, they don't get any refund. So consider how that would play out in the fall semester. If you do have an explicit enrollment agreement, consider the addition of a mandatory arbitration clause and a class action waiver clause. There are potential caveats to that. One is some institutions have made a decision, due to reputational harm, they don't want to require students to sign a mandatory arbitration or a class action waiver clause. And another downside to think about is if you decide to include one and it is included and the students sign it, do you want to be in a situation where theoretically you would have to defend thousands of arbitration claims at one time, or at least hundreds, rather than going through a class action and having one judge rule on that? I'll turn it over to Joel to address borrower defenses to the repayment rule.
Yeah, and this slide is okay, but just with respect to the last slide, with respect to mandatory arbitration and class action waiver clauses, there is a regulatory caveat as well, which is the borrower defenses to repayment rule. This is a Title IV rule. The short of it is, it used to be that you could not enter into one of these mandatory arbitration and class action waiver clauses for a breach of contract claim. The new rule that will go into place July 1 would allow you to do that, and you could enter into such a clause for a personal injury claim. But under the new rule, you have to include certain specific required notifications. So just be aware of that additional point. And moving on to another risk that's more regulatory in nature when it comes to students is student privacy law. And just very high level here, you'll have the slides. The likely federal legal rule that's going to apply is FERPA. That's the Education Student Privacy Law. It's not going to be HIPAA. The main rules of the road are, as I'm sure you all know, ordinarily you cannot disclose student information without consent, and that is going to likely include all information about a student's COVID-19 status. There is a health or safety emergency exception, and the Department of Education has put out guidance on when that health or safety emergency exception would apply. The guidance says the department's not interested in second guessing as long as there's a rational basis, and it suggests that a COVID-19 outbreak would qualify. Under that exception, you have to disclose the information to an appropriate party, which would include local health officials. It would not include the media. The guidance from the department also really expresses a preference for using non-personally identifiable information where possible. So if you can, alert students in a residence hall that someone on their floor has COVID-19, not necessarily that John Smith has COVID-19. There's also a model consent in the federal guidance. And if I could have this slide. So just by way of, heads up and looking forward to the fall in terms of trying to mitigate privacy liability around FERPA, we would suggest that you and the team consider FERPA in advance. You could, in theory, prepare written FERPA consents that you could ask students to sign that would allow you to do the test and trace that is recommended. And that could be subject to revocation. And in general, we'd suggest that you plan to implement those data minimization principles. So share only the information that is really necessary, while also preserving, of course, student safety. One more regulatory risk to flag here is the Clery Act. Folks often think of the Clery Act just as a crime disclosure statute, and it certainly is that. But there's also a requirement in Clery that you give a so-called timely warning and emergency notification where you have an immediate threat to health or safety of students and employees. And as we move through the fall, you should know that the Clery Handbook actually recognizes that disease outbreaks like meningitis or norovirus can be considered immediate threats. So I would say surely then COVID-19 could too. And if you are going to have to manage an outbreak, I think it would be important to be aware of Clery. Now I'll turn it over to George to address student disability issues.
Hi, everyone. My name is George Ingham. It's very nice to be able to present to you all today. So let's talk a little bit about the disability laws that apply here. If an individual is discriminated against on the basis of his or her disability, then this violates the law, and that's sort of a clear principle, but the laws provide other things that employers and universities and anyone sort of dealing in the disability space, here in this case, universities and students need to comply with, and those include providing a reasonable accommodation to someone who needs that accommodation and requests it for a disability, and also to prohibit asking certain questions relating to an individual's medical information or failing to keep that information confidential. And Joel just touched on some of that second point when talking about the privacy issues. But just to kind of focus on this as a practical matter, what does it mean when we are talking about COVID-19?
George,
yes.
We're hearing seeing in the chat that your microphone's a bit fuzzy.
Let's see, does that sound better?
Much better.
Okay, very good. I must have had the wrong microphone selected on my computer. Okay, so as a practical matter, when we're talking about disability related claims, or not claims, but issues, what does that mean practically when we're talking about COVID-19? It's okay to ask someone if they have COVID-19, if they have COVID-19 symptoms, or if they were exposed to COVID-19. It's okay if someone answers yes to those questions to ask them to self-quarantine and treat them differently in that sense. But the area that you have to be very careful about is treating people differently when they have a medical condition that might make them more vulnerable to COVID-19, unless such a person with a medical condition asks for an accommodation first. So in other words, you shouldn't go out and say that anyone with asthma cannot return to campus. That would be a problem and that would be a risk. Or to take people that you know have a potential medical issue and asking them proactively to be restricted in some way. But on the other hand, you know, it can be and should be appropriate that when someone comes forward and asks for an accommodation, to engage with them in the process. And on that score, could you go to the next slide, please? So this slide describes some things that universities can do to mitigate disability-related liability with respect to students. And you know, building from the last point, rather than asking individuals whether they're in categories that are considered vulnerable to COVID-19, it's safer to provide general education to members of the community about which types of individuals might be vulnerable to COVID-19, and the university's willingness to accommodate such individuals if they come forward or ask for such accommodations. Additionally, the university should ensure that it's prepared to smoothly handle disability accommodation requests. So that might include thinking in advance about the types of accommodation requests that are going to come forward and whether the university wants to have a streamlined approach with respect to certain requests. Next slide, please. So let's talk about potential claims by employees in the employment context. And as I hope the next several slides will make clear, the liability that universities face is not just about infections, and in some ways infections are just one of many different sources of liability, as Joel spoke of at the beginning. Next slide, please. So starting with the issue of contract claims, COVID-19 will, and in some cases already has, resulted in significant changes to certain terms and conditions of employment for employees. And some of the ways in which employment conditions might change could be pay cuts, there could be layoffs, there could be changes in the way that the job is performed due to safety or screening requirements or other similar issues. Some employees by contract may be entitled to certain employment rights. These may be set forth in an employment agreement, they may be set forth in an appointment letter, or they may be set forth in a faculty manual or even a collective bargaining agreement. And it's important to consider, actually, could you go to the next slide, please? Thank you. It's important to consider what rights employees have or may claim that they have if their terms and conditions of employment change. So it's important to think about what types of things are commonly included in employment agreements if they're provided, or appointment letters, and to understand the faculty manual to determine whether that implicates the decisions that the university is making. Additionally, if it is feasible, the university should consider whether any of these sources can be renegotiated or changed to reflect the current circumstances. Next slide, please. So as I said before, liability relating to COVID-19 is not just about infections. This slide sets forth at a high level some of the other employment law issues that are likely to come up. As discussed on the student slides, one of these issues is disability related. So the disability laws, which would include the ADA as well as Section 504 of the Rehabilitation Act, require accommodating an individual with a disability, or at least attempting to accommodate with a reasonable accommodation. And failure to do so could result in a violation of the law. It also may violate the disability laws to reveal the identity of an employee with a COVID-19 infection, or to ask prohibited inquiries about medical information. Another potential source of liability is that the Federal Occupational, State, and Health Administration, or a similar state agency, may conduct a workplace inspection and could cite an employer if it did not furnish a place of employment that's free from recognized hazards. This can lead to monetary penalties. Additionally, there's potential wage and hour liability. If you have hourly employees and they are spending a portion of their time undergoing safety precautions such as screening or getting a temperature check or taking a COVID-19 test, if they are not being paid for that time, then depending on state law and depending on the specific facts, they could have a claim. Additionally, if you have employees who were previously performing roles as exempt employees and they are being asked to perform different roles as a result of the pandemic, and those different roles are non-exempt roles, it may be that you have inadvertently made them overtime eligible. So you have to be very careful about taking somebody in one role and having them spend a significant portion of their time in another role. Another source of potential liability is failure to comply with leave laws. These could include state paid sick leave laws, the Family and Medical Leave Act, or for covered universities, the Families First Coronavirus Response Act, which is a law that came out just before the CARES Act. If an employee engages in protected activity, and protected activity can be a number of things, but in the COVID-19 context could include complaining about safety issues. If such an employee subsequently suffers an adverse employment action, that employee may be able to sue for retaliation. Additionally, if some portion of the workforce is unionized, the employer could face liability if it fails to bargain with the union over safety measures, depending on the wording of the collective bargaining agreement. Additionally, there's potential liability if there is a layoff or a lengthy furlough or work hour reduction that could trigger obligations under the WARN Act, which is a federal law, or a state WARN statute that would require giving notice to affected employees. And then, of course, if a university is taking action that is not even-handed or could be perceived as not even-handed, it could face discrimination claims. Next slide, please. So like with students, universities really need to be prepared. I think the issue of accommodation is one that we're going to see very frequently in the education space. And I think universities really should think about what accommodations is it going to expect to see and what types of accommodations is it going to be willing to grant in advance, just to make sure that one, the university is prepared for these requests, but two, that it's going to be processing these in an even-handed manner. And a lot of the requests that we're seeing are telework, extended leave, working in a less busy area of the campus, working in an area with appropriate dividers, and other things of that nature. But in addition to thinking about those, it's important to understand that supervisors need to understand what to do if they get accommodation requests. Who do they direct these requests to so they're handled in a consistent manner? And that typically should be a person or a group in human resources. Like with students, universities, just as it's better to provide education to everyone about who is at risk rather than asking individuals whether they are at risk, we think that it's a good idea to notify the entire campus through general outreach that the university is willing to accommodate persons who need it, and to provide information that the CDC has put out on those who are vulnerable so that individuals can come forward if they wish to request accommodations. It's also important to maintain the confidentiality of medical information. Do not reveal the name of someone who tested positive for COVID-19. And then another issue, and this is part legal and part practical, is to be prepared to confront what I'll call these difficult issues that come up. And some of the things that we've been seeing frequently are what happens if you have someone who does not have a disability and they don't have a right to leave, but they refuse or they're reluctant to return to work for another reason. Perhaps they're just afraid of contracting COVID-19, or they have a family member who's in a vulnerable group. And you need to think about what the university's policy is going to be on that and how it's going to treat these people in an even-handed manner, because that issue has been coming up, and it likely will continue to come up. Other issues could be issues relating to face coverings and employees who are, resistant to wearing those for a medical reason. And that requires both consulting state law as well as how the university wants to proceed as a policy matter as well. Universities also need to pay very close attention to the ever-evolving guidance, not only from OSHA and CDC, but by the EEOC, the Equal Employment Opportunity Commission. The EEOC has largely stated that if you follow CDC and OSHA guidance, that the EEOC believes that to comply with federal anti-discrimination laws, but it's very important to stay on top of that because all that guidance is changing very rapidly. Next slide, please. I'm going to mention workers' comp here very briefly. We're going to cover the substance of workers' comp later in the presentation after we talk about some of the tort liability issues. So at this time, I'm going to pass the presentation back to Michael, who's going to talk about that.
Thanks very much, George. If we go to the next slide, this slide covers what happens if somebody contracts COVID-19 and as a result of that illness, they sue the institution. Such a tort claim would be governed by state law, and the elements are duty, breach, causation, and injury, which we will then, which I'll address in future slides. So the key from this slide, the important issue that I'd like to draw everyone's attention to is there are typically two types of theories when somebody becomes ill due to an illness like this. One is just they allege that somehow the institution allegedly breached the duty to protect them and provide a safe environment. And that is something that can be a challenge to provide an environment that is going to prevent all students or all members of the community from having any risk of COVID, because of course we all know that COVID has a high degree of transmissibility. And the nature of university operations with a living and learning environment is such that it is safe to say that it's impossible to eliminate all that risk. So the second theory is a duty to warn. And where that would come in is, let's say a student says, yes, I admit that the institution was doing everything reasonable to protect me. However, I had no idea that the level of risk in a university community would be as high as I have since learned it to be. So essentially what that sort of claim would be is if an institution has consulted with experts and has learned that, for example, there are just some risks that cannot be eliminated, that sort of failure to warn claim is essentially an allegation that the institution in that instance had a duty to warn the student and to tell the student essentially, if you want to come back to campus, that is great, we welcome you back. However, keep in mind that we cannot eliminate all the risk of the transmissibility of COVID, no matter what we do. And so if you come back, you have to accept those risks. So those sorts of those sorts of warnings are something that can reduce the risk of a successful failure to warn claim. And to a large degree, that depends on the level of the warning. The stronger the warning is and the more risks it discloses and the more explicit it is, the better it's going to be at protecting against a future failure to warn claim. So let's turn now to the standard of care. In the last slide, we talked about a student who would say, theoretically, well, I understand the institution did everything reasonably possible. So let's say now a different student says, no, I think the institution should have done something more. And this gets to a court. What is the standard of care that an institution would be held up to? Well, the bad news is that in the world of tort, there is no, let me put it this way, compliance with government standards and compliance with what other institutions are doing are not necessarily something that is going to shield a university from all liability. A jury is theoretically able to say, you complied with all the applicable standards, but I still think you should have done more. You should have gone above and beyond what everybody was doing, and you should have done something innovative here. Now, that's the bad news. The good news is that typically what judges look at, what juries look at, what plaintiffs' counsel look at is what are the applicable government standards and what are other similar institutions doing. So the best, what most institutions do in that situation is, one, try to comply with all the government standards that are applicable, all the standards of other institutions. And then if there's something more that they think is reasonable to do or it has been suggested to them to do, that's something that there's a strong argument to do. Next slide. So last point I want to leave everyone on this topic, and then we can go on to the next topic is, what about family members? Let's say a student becomes ill and they go and visit their family, and then the family becomes ill. Can that family member sue the institution, even though maybe they never stepped foot on the university campus? The answer is, since I'm a lawyer, you won't be surprised I say this, it depends. What does it depend on? It depends in large part on what jurisdiction you're in, because different jurisdictions have different approaches. The courts are split. Some courts have said, generally speaking, the institution would have no duty to a third party, and other courts have said that if it's foreseeable that a injured member of the community could transmit that to a family member, then a duty exists to protect that family member. Thank you. Let me go over this last slide very quickly. I thought I would be able to turn it over to one of my colleagues a little bit more quickly. These are just a list of the various defenses, and I'll just draw your attention to two in particular. Assumption of risk. Again, if you fully warned members of the community, that could be the basis for an assumption of risk. And causation. Very important, because in many instances, it's going to be difficult for members of the community to establish exactly how they became ill. Did they become ill from another student, or perhaps from somebody when they went off campus to a restaurant? Did they become ill from that contact? So George, I'll turn it back over to you.
Great, thank you, Michael. So I want to speak about workers' compensation briefly. Workers' compensation is a state law regime. There are 50 different workers' compensation regimes, but there's some common themes that I'll talk about. For specifics, you have to consult your state law. But very briefly, workers' compensation is essentially a grand bargain between employers and employees, in that let's start with employees. Employees get a streamlined path to benefits. They don't have to prove fault to recover under workers' comp. On the other hand, employers get to avoid civil lawsuits, and the remedies that are available under workers' compensation are limited. So for example, there are no punitive damages. in workers' compensation. So what do you have to do to prevail on a workers' compensation claim if you're an employee? Let me just headline this with, it is not the case that every single COVID-19 infection is going to be covered by workers' compensation. In fact, under traditional unamended state law, a lot of these claims will not be covered by workers' compensation. And so you have to show two things to prevail under workers' compensation. One is you have to show causation. And as Michael just talked about, that is easier said than done. It is difficult to show where you contracted COVID-19 unless there are some particular facts that show that that's an issue. And then the other thing that you need to show in many states, not all, but in many, you have to show that the illness that you contracted, in the case of an illness like COVID-19, is that it is peculiar to the nature of the occupation that you are in. So in the COVID-19 context, that is going to be very difficult for someone to show if they're just working in more of an office setting. On the other hand, if you're working providing healthcare to people who are COVID-19 patients, then it's going to be easier to show. So that's sort of the default rule. That said, a lot of states have been changing their laws. And at current count, there are 12 states that have adopted varying forms of workers' compensation liability expansion that make it more likely that workers' compensation is going to apply. And California is one example of these. It's adopted a presumption that anyone who tests positive for COVID-19 within 14 days of reporting to a work site has contracted the illness in the course of employment. So that is the trend that we're seeing, is that this is getting broader, but under a lot of state laws, it is not a sure thing that workers' comp applies. And so the question is, if it doesn't apply, can someone sue in tort? The answer to that is it depends on state law, unfortunately. But with that briefly behind us, I'm going to turn it back to Joel to cover a new topic.
All right, and I'll just quickly touch on this slide, and then I think in the interest of time, Paula, we're going to zoom ahead to the top 10 strategies that we've got, and then I would invite George and Michael as we cover those top 10, maybe to chime in as folks think about their questions and put them in the chat, because I also note that the chat is sort of bereft of questions at this point, and we really do want to get to those. Just quickly on immunity, I would say monitor the federal space. There have been some moves, and the Washington Post, for what it's worth, just came out in support of federal immunity for institutions that reopen, and there may be some immunity protection under state law. And if I were you, I would want to know that as I move into the fall. And the other thing I would want to know, I would want to check with general counsel or risk or compliance. What's our picture around insurance? Do we have the insurance we need? Does it cover what I think it covers? Do we have the right mix? So then, Paul, if you could zoom down to the top 10, and you all will have, keep going, oh, back. You all will have access to both this recording and to the PowerPoint. So there is some more information in there. So just to run through these 10, and again, George and Michael, feel free to jump in. The first one, my bet is everybody on this call has one, but if you don't, create a task force, both to plan for the fall, but also to stay on top of the fall and to continuously monitor your environment. Number 2 is conduct a hazard assessment. Develop safety protocols, including screening and monitoring, social distancing, face coverings, and develop a plan for dealing with infections and outbreaks. Like Michael said, we're never going to get the risk down to 0. So we need to be ready to manage those outbreaks. Third, this legal risk is now entirely in our control. We know what happened in the spring with the move online. There's no reason why we can't review and revise enrollment agreements to state accurately what educational services we are providing in exchange for tuition. So we should flag that we may need to move to online, and that what we're delivering is the education, and consider a force majeure clause in those enrollment agreements or in those disclosures. 4, seek to, plan to, try to give students and employees the option to return to campus. That would help with assumption of risk. It would show we care about our students. And the fact of the matter is, you're probably going to face accommodation claims where you're going to need to provide education remotely, or at least that will be the argument. So why not plan for it if you can? Number 5, provide members of the community with accurate information about the risks of COVID-19. Earlier in my career, I was involved in a case where a school took a trip abroad. They were subject to a $41 million judgment because a participant got tick-borne encephalitis. And part of the theory was the institution, we wrote an amicus brief in the case, we did not represent the institution, but it linked to the wrong CDC page. So it's important to pay attention to details too. And the next slide, please. Require students and employees returning to campus to agree in writing to acknowledge the risks and comply with safety protocols. You might need to make changes, this is number 7, to your codes of conduct and student handbooks to make compliance with mitigation requirements mandatory, and you should enforce those. 8 is the evaluate insurance coverage. 9 is make a considered judgment about liability waivers or arbitration clauses or class action waivers as a tool or a lever to mitigate liability. And 10, don't forget about liability other than infections. So this is the disability, accommodation, wage and hour, and discrimination.
And this is George Ingham. I wanted to chime in on a couple of points, and then I see we have a question here that I'd also like to give an answer to. So one thing that I think is just absolutely critical is that this is a moving target that universities, like all businesses that are trying to get ready to reopen or operate, are facing. And these guidelines that we're seeing from the federal government are changing rapidly, and we should expect that they will continue to do so as the situation evolves. And really what change we're going to see is going to depend in part on the status of COVID-19 and what infections are looking like over time. Additionally, and almost more importantly, is what is the status in the location where you are. So different parts of the country are going to face different challenges. And in addition to the federal guidance, there are state and local requirements that have to be considered as well. And that actually is a good segue into the question that has come in that asked, is there any advice on whether we're better served by having our signage around campus say masks required, or masks required if you cannot socially distance? And I think the first answer to that question is to check your state and local requirements, because under certain states and localities, there's just a flat requirement for masks in the workplace in almost all settings. And then in others, it's more along the lines of you need to have a face covering if you cannot socially distance by 6 feet. So I think the first thing is to check that. Secondly, is just to look overall at what the current state of CDC guidance is. Right now, CDC guidance is advisory, and CDC guidance would give you the discretion to choose one or the other. But I think the first thing is really just to see what your local requirements are. I think we have some other questions.
This is Michael. And this is Michael. Let me just chime in and keep in mind that if you follow since, as George noted, the CDC advisory is discretionary. If you decide not to implement a requirement for masks because the CDC has said that that is discretionary in a tort claim, and I'm distinguishing that from an employment claim under workers' comp, but in a tort claim, a student can allege that the institution should have gone further and should have exercised its discretion to require masks. So just keep that in mind. Anytime your institution has discretion and you decide not to exercise that discretion in a way that would be the most protective of students, you can be second-guessed.
And then we had a question, Michael, that I think I would kick to you, which is, what about if we just put signs on campus that say clearly that if you show up to work or campus, you're agreeing to assume the risks around COVID-19, that option, as opposed to, having a student or an employee actually sign an acknowledgement of risks?
Well, I think that it's a great question, and the problem with just putting up signs in lieu of asking students to sign is that for a student who has already paid their tuition and who is on campus, they may say that they were not in a position to back out once they saw those signs. And they may also say some courts have focused on when is the meeting of the mind. So when did the agreement occur? And what some courts have said is if the student and let's say the institution made a decision as to what would happen in the event of the university re-enrolling, and then the student gets on campus and sees a sign, one argument the student can make is that was a unilateral decision by the university to try to change the terms of the bargain, and the student wasn't given an option to say no, and so there wasn't a meeting of the mind. So really best practices would be to ask to make sure before the student pays tuition and comes back to campus to be fully informed and to ask them to acknowledge their acceptance of any risks.
And there was a follow-up question, which was, well, okay, you don't like signs, Michael. How about sending an email to that effect before classes start?
Yeah, if an agreement is out of the question, an email prior to classes starting is a much better solution, because then the university can later argue, look, we laid it on the line well before the students got to campus. We made it quite clear these were the conditions. So I would rank them in among those three options. Explicit agreement is best. Second would be an explicit email before the student gets to campus, and ideally before they've paid tuition. And then third would be signs around campus saying that they have accepted certain terms.
We may have time for one more quick question.
Okay. And I think the question that I'm seeing, Paula, is, are there examples of language regarding the acceptance or sign off of risk statements for employees and students? So essentially looking for forms or model language that folks can use.
I'm not aware of any forms right now.
Yeah, let me at least add a little bit of a concept here. I couldn't recite specific language right now, but the key thing I think here is that you're having the employees acknowledge both that they understand the risk, well, you're having them acknowledge that they understand the risk. There's some level of disclosure in that here are the risks that you're acknowledging, and that you put that out. Not in a way that's intended to scare anyone, but that's intended to disclose what those risks are, and then that they acknowledge they fully understand what those risks are, and that they are assuming those by coming to campus. I think those would be some key components. And one thing that I would suggest that we touched on briefly in the presentation is that in addition to acknowledging the risks, I think it's important that people also agree that they're going to comply with the safety protocols that exist and are amended from time to time while they're on campus. So it's not just about we're trying to get people to not be able to sue us, but we're also getting people to agree that they're going to commit, that everybody's in this together and we all need to comply with the safety requirements. I would say that that's a component that I would suggest as well.
Great. And I'm afraid that on that really good nugget of information, we are going to have to wrap up in the interest of time. So I think all that's left is for me to thank all of our speakers, George, Michael, and Joel. Thank you so much for your insights. I want to thank all of our participants for joining us. By Wednesday of this week, if not earlier, you will find recordings of all 3 of our webinars on the ACCU website. That's acunet.org/COVID-19. And there you will also find a way to provide us with topics for future conversations. Thank you again all for engaging with ACCU. God bless you all and stay healthy.
Thank you. Our pleasure.
Thank you.
Thank you.
Thank you so much.